How you doing today, peoples and peepettes? I want to get into some things that can kind of help some people in regards to foreclosures, repossessions, etc. And I'm going to talk about my fragrance that I'm wearing today, which is Imaginary Authors Cape Heartache. So we're going to get into some of the equitable remedies that are available. So if you remember, I did a video talking about that you have the right to rescission in regards to almost all credit contracts. And then you hear people on the internet saying that you don't. There's going to be a contradictory statement in that because there always is a basis of knowledge. When people tell you you can't do something, it might be limited to their knowledge. What I try to do on this channel is break things down simple so you're not going all over the place to figure out how to deal with simple contract issues. So if you see what I'm saying might not conform or jive with other people, um, it's not a bad thing. It's just our levels of understanding may be different. So now with all that yammering, I'm going to get into this publication. Now, a lot of times when people ask me, like they say I'm a internet lawyer or I don't know what I'm talking about, etc. Um, a lot of them don't understand what I read. So I get most of my information that I'm getting from attorneys, if not attorney law reviews or law books. So it's not like I'm making this stuff up. You see what I'm saying? I'm not telling you to file a bunch of word salad in court or do anything. You can beat court just by keeping it simple. Okay. So now we'll just get into some of the equitable contract remedies. So sometimes when I'm reading, the words are so small because some of these publications come out small. That's why you might see me make errors when I'm reading it. But we'll just come on, we'll just do what we need to. Equitable contract remedies, denial of both specific performance and rescission. Serious problems of doing justice between parties to a contract arise where on one hand, on the one hand, specific performance of the contract is refused on equitable grounds such as hardship, and on the other hand, rescission of the contract is denied and the contract is allowed to stand as a binding legal obligation. The objects of the present comment are the two. To example, to examine critically the situation where this result has actually been reached, and to inquire whether there is any real advantage in the administration of contract remedies in recognition an immediate ground between specific performance and rescission. So if people have done consultations, you should already know what I'm talking about when I'm talking about this in regards to mortgages, etc. People have a kind of think predetermination that they always want to rescind a mortgage. You don't always have to rescind a mortgage in regards to enforcing the your rights in regards to it. Same thing with car loans too. Okay, perhaps no principle of equity is more firmly established in Anglo-American law than the rule the specific performance of a contract is not a matter of a right, but a matter lying in the discretion of the court. This holds even in the case of agreements for a transfer of land. Whereas a matter of practice, specific relief is almost always granted. See? But this does not mean that the chancellor can do as he pleases about granting relief, for his discretion is not arbitrary or capricious one, depending upon the mere pleasures of the judge. So if you want to look at the video where I was talking about the myth of judicial immunity, a judge cannot just do what he wants on the stand. Uh, a lot of times what people do is they'll allow a judge to do whatever he wants, but then they don't check that judge. See, the reality is you are really the one that's controlling the court, but you don't understand court. So then you still see the government as some god over you that you're punching up and trying to fight, and you're not understanding you're lording over them. And that's why a lot of times people say none of this stuff works. You guys don't know what you're talking about. This is crazy. Blah 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 blah. The reason why people tell you that is because they're so used to following rules and being told what to do and where to shit and where to eat, that they can't believe that there is some other way. Okay, but one which is governed by equitable doctrines. Although the rule of this discretion has been severely attacked by Pomeroy as being misleading, it is now so generally accepted to go without question. The assumption on which the principle rests undoubtedly is the specific performance is merely an alternative remedy, and that if it be denied, there will be there will remain another less satisfactory remedy at law for the enforcement of the defendant's obligation. By contrast with specific performance or damages for breach, a third possible remedy, rescission, is drastic. Whether rescission is affected by an appropriate legal remedy or by an equity decree, this result is the annihilation of the contract and the defeat of whatever expectations may have been aroused in the other party. It is therefore natural that the remedy of rescission should be extended reluctantly and with some regard for the larger social interests, which reinforce the specific interests of the opposite party in particular transactions. So when I used to do, not used to, but I still do deal with mortgages, people would come to me saying, I send them a letter of rescission. And then I would tell them, well, what did your letter of rescission say? Or I would say something to them in lieu of, or not, kind of in the realm of, okay, what did you do to enforce your rights of rescission? And then then when I would tell the person, you may want to send another letter to rescind, they would say, I already did that. Or if I tell a person, you might want to do a debt balance, I already did that. This is when I deal with people like this, I usually let them go, because what happens is sometimes people do not understand the crux of everything. You have to let these people go on their own path. So a lot of times when people come to me with other people's remedies, I'll just say that may work. I'm not going to tear another person down. I had to learn that myself because I'm not in competition with anybody. Okay, the concurrence of these two lines of reasoning: one, the relating to specific performance, and two, relating to the rescission, will often face courts of equity into immediate possession, although specific circumstances of hardship or personal inequality may result in the refusal of specific performance. These circumstances may nevertheless be insufficient for rescission, either at law or in equity, and the contract will remain as valid obligation and as such the basis for an action at law for damages. This result is clearly within the contemplation of the courts and writers who assert the discretionary basis of specific performance in such empathic terms. So, like a lot of times when we're dealing with law, we have to understand that the grounds have to be fair. I can't try to do something to harm you, and you can't do something to harm me. That's a law of nature. So if somebody does something to harm you, or someone is taking action which can potentially cause you harm, that's why there is an equitable way. They may have a legal right to things, but equity is there to basically balance it. You may sign an agreement, I may have the legal right to take your home, but in equity, In equity, um, that may be unequitable because that's your only home and you won't have another place to stay. So you have to understand equity because there's a lot of people teaching equity, and there's some people who know what they're talking about with equity, but an equitable sense has to be fair. That's what it is. It's like, okay, we know that this is the law, but it's fair. But usually, law and equity are infused. So if a contract is legal, that means that somebody is just enforcing it because they have a legal right to do so. But it may not be equitable if you bring it into court. But all contracts to be enforced by law have to be equitable. That's why there's consideration and value. Okay, there are a few decisions with which proceed on that theory that no middle ground can be taken between specific performance and rescission. Thus, it has been held that in general, when a specific performance is denied, a rescission will be decreed. See, I don't think you guys understand the amount of information I just gave you. See, when you're watching my videos, they're more jam packed with information and condensed. I'm not going to talk for 50 minutes and give you 5 seconds worth of information just to entertain you. See, back in the days, my videos were entertaining. I used to be, going out and hanging out and showing people different states and traveling and all that other stuff and talking about relationships. I'm going to go back to that. But for now, I want to give people a fighting chance. Listen to what I just said. That was a bar. Okay. Moreover, the Kansas court has said by way of dictum that rescission of a contract will be granted on the sole ground that the delay in performance has caused such damages as will render a decree of specific performance inequitable and unjust. But on the whole, the distinction between the basis for refusing, sorry, specific performance and the basis for allowing rescission has been established by a most respectable group of authorities. Indeed, it would be safe to say that the main body of specific performance doctrine is based on an assumption that the specific performance um, may be refused for reasons quite independent of the test for rescission. In a group of cases involving mistake, the result we're discussing has been obtained. Both rescission and specific performance have been denied, leaving the contract binding at law but not enforceable in equity. See? So now there's a difference. So they're saying that a contract is enforceable in law but not equity. That's why I read these reviews, because when you read these reviews, they will tell you, okay, in order to obtain rescission of a contract on the grounds of mistake, the evidence of mistake must be strong and convincing. A mere preponderance is insufficient, but although the evidence will not warrant a rescission, it may constitute a bar to relief by way of specific performance. The inequitable circumstances generally, but not always relied on, is the fact that the party seeking specific relief knew of the unfair advantage he was getting at the time of the consummation of the contract. What did I tell people? Consummation can mean different times. It could mean the fulfilling of the contract or the inception of the contract. Although it is well established in most jurisdictions that the purchaser is under no obligation to disclose facts relating to the value of the land sold, it has been stated that the vendor must set up as a defense to the suit for specific performance. Bar, another bar. a concealment of such facts, even though rescission would be unwarranted. But most of the cases cited as sustaining the principle contain other factors of hardship or personal inequality. So you have to understand one thing. This is basically telling you guys how to get your house free and clear, your cars free and clear. You need to pay attention to what I'm saying in this, and you need to watch it a numerous amount of time. Okay. A number of cases have gone so far as to decree specific performance in such circumstances, but there are at least two decisions to the effect that such a non fraudulent concealment, although not grounds for rescission, constitute a bar to a suit for specific performance by the purchaser. In some early English cases, an effort was made after the denial of specific performance on an account of hardship to control the subsequent operation of the damage remedy. For example, in the case of Savage versus Taylor, Lord Chancellor Talbot decreed that although the purchaser could not have specific performance because of hardship, he should be compensated for improvements made while he was in possession on the condition that he delivered up the contract and account for the profits otherwise. If he goes, he delivered up the contract. They delivered up the contract. Okay. Oh, that was a bar too. Okay. If he goes on at law, he might not expect it. Again, in Day versus Newman, where the purchaser's prayer for specific performance was denied because of inadequacy of consideration, coupled with other inequitable circumstances. See, you have to understand why they're being denied. So that's the one thing I love about these law reviews and some of that stuff. Because, okay, let me explain this in law to you. Okay, so it says again in Day versus Newman, where the purchaser's prayer for specific performance was denied. So it was denied because of the inadequacy of consideration. Well, if there is no consideration in regards to an agreement, then it's unenforceable. So the court denied it. Oh my goodness, what happened to it? Okay, there we go. Coupled with inadequate circumstance. Is this it? Oh my goodness. All right, there we go. Yeah, we're back. Okay, so coupled with other inequitable circumstances, and the cross bill for rescission was also dismissed because there was no showing of fraud. The master of the rolls offered to dismiss the original bill. See, that's what you. This is what when I'm talking about the fireside chats. Go watch some of my fireside chats. Some of them are on YouTube, and some of them are on Instagram. That's why I'm saying when someone sends you a bill or if they're suing you through court, what they're doing is sending you a bill. So then they're summoning you through the court to answer to their bill. If you don't have a counter bill or a cross bill or a cross claim, then you are going to lose in most instances unless you cancel out their bill. I hope you understand that. That was more than a bar right there. Okay, without cost and the cross bill, without cost to the complaint purchaser, if he would deliver up the contract for cancellation, but the complainant's refusal to comply with the condition, both bills were dismissed without cause. On the other hand, in Bernard's Dinston versus Linggood, where the court could not control the damage remedy, it decreed rescission after refusing specific performance. The court regarded equitable rescission as necessary because the mischief was done at law, for a judgment was given in favor of the vendor for £6,000 as security for performance of the agreement. No fraud was shown, and the only unconscionable feature of the case was hardship. And inquiring into the effects of refusing specific performance but allowing a contract to stand unrescinded, one is faced with the fact that the refusal of specific performance may often, uh, though quite indirectly, result as denial of relief. Um, this consequence may be expected whenever the test for the plaintiff's performance of conditions are stricter at law than in equity. For example, in recently decided case of Doppers versus Hand, specific performance of a land contract at the suit of the vendor was denied on the grounds that the performance would be unconscionable because a 6-day delay in perfecting title had resulted in the purchaser's loss of financial assistance promised by the local bank. A cross complaint for rescission and recovery of the down payment was likewise denied. The theory of the court being that the vendor's breach was insufficient to warrant relief. Nothing was uh, intimated about a subsequent action at law. Man, these words are getting smaller and smaller. The effect of the decision, so far as the complainant vendor was concerned, was a rescission of the contract, time being of the essence. At law, in executory contracts for the sale of land, the vendor could not maintain an action for damages because of his non-performance of the condition precedent to the purchaser's obligation to perform VIZ, perfecting title on the day set. The decisions could be criticized only for failing to provide for restitution of the purchaser's down payment, which could normally be had in quasi contractual actions at law on these facts, but which would apparently be precluded by the court's express refusal of rescission and restitution, even if it does not result in a denial of all relief. Refusal for of specific performance may sometimes have subsequently this effect on practical operations of the legal remedy, as in the case of like Dropper's case in jurisdiction where the rules of damages precludes recovery by the purchaser of the value of the bargain in the case of default by a vendor of land, a purchaser having been denied specific performance because of the unconscionableness of the contract could recover only nominal damages in subsequent at law action at law. In such jurisdiction, the procedure of dismissing the bill results in substantial alleviation of hardship in both equity and at law. But the nominal damages rule is generally followed, um, and such a result could therefore only be rarely attained. Moreover, where the purchaser is in default, prevailing rules of damages will allow the vendor subsequent substantial damages. Indeed, speculation as to the ultimate disposition of a normal case inevitably leads to the conclusion that although refusal of specific performance may alleviate hardship in equity, the application of strict rules of contract damages and subsequent action at law is likely to result in the imposition of severe burden on the party in default. For instance, consider the situation where a credulous purchaser is what? Where's that? Oh no, where did I go? Uh, where am I at? Credulous purchaser is permitted to set up inadequacy of consideration and lack of business experience as a bar to suit for a specific performance of a contract for the exchange of land. Under conventional notions, the plaintiff would still have his remedy at law, wherein he would recover the damages measured by the differences between the fair values of the lot. Obviously, the greater inadequacy, i.e., hardship, the greater would be the damages. If the chancellor conscience rebels at the thought of specifically enforcing so hard a bargain, why is it so easy appeased by a dismissal of the bill, which opens the door to the imposition of heavy damages at law? It has been suggested in answer that a jury in a court of law can mitigate damages according to equity and good conscience. So if you think about equity, how is equity being done? If you get into a mortgage, the bank is allowed to foreclose your property and then basically say that you owe them $100,000. That is unequitable. But see, since people did not raise their rights, that's how a foreclosure takes place. In view, or they let the court process steamroll them and they do not answer, they don't object, they don't challenge the orders that are entered. Okay. In view of the fact that in modern law, the jury is bound to assess damages in according with the rules of law propounded by the court, such a proposition seemed not altogether convincing, but it may be borne in mind that under the early law, the question of quantum of damages, even in contract actions, was a matter of resting entirely in the discretion of the jury. There were no legal rules to check abuses of that discretion. Reliance was placed on certain mechanisms such as the writ of attaining, the writ of inquiry, and in rare cases, the procedure of granting a new trial, which would be a trial de novo. So if you lose a foreclosure trial, you can request a trial de novo also, for some of you guys that don't know that. It was not until the close of 8th century, 18th century. You can also do that for repossessions too if you're brought into court. That the jury lost its equitable powers, and it was at the least half a century thereafter that our leading rules of damages were evolved. According and Accordingly, an assertion by a chancellor in 1824 that the parties could be sent from a court of equity to a court of law to obtain equity was perfectly intelligible. Indeed, the early discretion powers of the jury provide a rational basis for equity transitional attitude to toward cases of hardship. Formally, a dismissal of the bill would alleviate hardship not only in equity. Listen to what they are saying. but also at law. So they're basically saying, if this is where predatory lending kicks in. Everybody tries to tell you that, oh, there's racism and there's predatory lending and race. I'm telling you as a person that did mortgage foreclosures, that's BS. Racism is a big business because they want to deter so-called minorities, which are so-called indigenous people. They want to stop you from owning property. So that's why you have certain kind of people like, I'm not gonna say their name because when I said the person's name last time, I got death threats when I did a video about him being a scammer using race and baiting people through race. Um, what they do is they use these people to try to deter so-called black people from owning businesses and applying for home loans because they say it's racist. So then some people don't even try, not understanding that when a bank approves your loan, they only approve it on your financial state, like your financials and the documents, not your race. Now they talk about redlining and all that other stuff. Yeah, there was redlining and all that. That is fact. But just because you are a certain race, I mean, there's laws to provide, to stop basically people from denying you credit based on your race. And you can use that also if you feel, but be careful. Assuming that the jury exercises power of mitigation. If that is a reason for the equitable rule of hardship, can it not be argued that the modern courts of equity are proceeding on the wrong assumption and leaving the parties to their damage remedies, um, which now may be almost a harsh as specific execution of the contract? The unsatisfactory result of the traditional reasoning is clearly shown in the New York case Kleinberg versus Reddit, where the plaintiff, as purchasers, sued for a rescission of the contract and to recover a down payment alleging fraud and an incumbents on the title. A cross bill was filed for a specific performance, but both bills were dismissed, the court proceeding on the grounds that the rescission could not be granted because no case was made showing either fraud or breach of warranty, but that specific performance could be refused because of hardship. See, that's a bar. So, specific performance can be refused because of hardship. That is a bar. Neither in this case nor in typical cases of hardship considered above did the appellate courts denying specific performance make any express reference to ultimate outcome that may be expected in law action. This neglect is especially unfortunate in Kleinberg versus Reddit, where the restitution of the purchaser's substantial down payment was expressly refused and the purchaser was confronted with alternative of abandoning his down payment or else performing a burden some contract. Uh, it has been pointed out that the test for substantial performance are immediately connected with the test for rescission. So what they're basically saying is this, what I've been teaching people is that you can either rescind a contract or demand that it's performed. You see what I'm saying? So in some instances, one may be higher than the other. So if a contract is an adhesion contract, then you can rescind. If it is a legal contract, then you can request performance. Okay. Test for rescission and restitution in favor of the party in default. It seems clear that in refusing specific performance, At the same time, expressly denying rescission, there should be even closer scrutiny of the legal remedy in damages, which is thus deliberated, preserved. One method of linking uh, the specific and damage remedies more closely would be for equity to retain the case for assessment of damages after the refusal of specific performance. The chief obstacle of this to this treatment, the constitutionality, the constitutional guarantee of a jury trial has been surmounted in most states where the question has been raised. Uh, but while uh, the intimate connection between the remedies would be most more strikingly shown by this method, it would throw no light on the larger question where a mere denial of specific performance can alleviate hardship. Indeed, so what the man, oh my God, for all y'all people who've been doing consultations, we've been bringing this up, uh, how specific performance can alleviate hardship. Listen to those calls again, and then it'll bring it together of what I was talking about with the mortgage and demanding this. It'll basically get you out of your mortgage. Okay. Indeed, the quantum of damages assessed by equity would substantially correspond to the amount that would be assessed at law. The chancellor and the jury would be equally bound by the now crystallized rules of contract damages. Indeed, it is possible that those rules will be more strictly applied by a chancellor than a jury of plain men. On the whole, it is remarkable that modern courts of equity should persist in an approach to the problem of specific performance that bears so little relation to the realities of modern contracts. Perhaps it is to be explained by a feeling that the remedy of specific performance is inherently superior to the damage remedy, and that to refuse it on moral grounds will therefore prevent the plaintiff from securing the full benefit of hard bargain. Uh, But we have seen, so what they're saying is that the plaintiff, they don't want to, they don't want it to where people are just abridging and breaking their contracts. So that's why there has to be a certain general standard. That's why sometimes you can't get out of contracts, and you're like, well, how come I can't get out of this contract? Because they don't want to set a social standard that you can create a contract and just abridge it at any time. You see what I'm saying? So like if you understand when people say there's public and there's private, you have to understand that what they're meaning is there's public perception and then there's private reality. The public perception might be I'm an a-hole, I'm stupid, I don't know anything. But the reality might be I might be a genius, or I might be smart, or I might be ever, or I might be dumb, or whatever. That's what public and private is. Okay, so to keep a social norm, because you wouldn't want to pay somebody and then sign an agreement, and then they say, "Oh, nope, nope, we don't have to do it. We now rescind it, and we get to keep the funds, and you should have never gave it to us without looking up our track record." You see what I'm saying? So there has to be some type of balance. Okay. So look, but we have seen that even this assumption will not bear close scrutiny. It is clear in modern law that specific performance goes as, of course, in contracts for the sale of land without any special showing of the uniqueness of the particular uh, tract. With the settled practice One is not disposed to quarrel, for it is given us a relatively simple formula in a field where formulae are few. But where elements of hardships appear, it may be doubted whenever a particular tract of land is so unique or damages are so speculative that the plaintiff, even when restricted to his remedy at law, is at a great disadvantage. In many cases, the cash equivalent may be more desirable than the land itself, even when the account is taken of difficulties in the way of measuring cash value. See, they still measure defaulted accounts as cash value because the bill is the money. It's always been this way. If you have a bill, you're holding money, not money in the sense of law, like lawfulness, but money in the sense of legal interest. So the same considerations would apply through less forcibly, though less forcibly, sorry, to contracts relating to personal property.